Welcome back to Good Law, Bad Law. If you're watching the news these days, it's not good. And you might be well thinking, I need a drink because I can't handle this. Or maybe you can and you love it and you still want to have a drink and celebrate. Either way, you will enjoy today's episode because we are talking today with Brian Haara. He is a lawyer in Louisville, Kentucky, and he's the author of a new book called Bourbon Justice, How Whiskey Law Shaped America. And you might not believe it. And I didn't really fully believe it until I read the book and so thoroughly enjoyed my conversation with Bourbon, the many, many ways, not only that whiskey and bourbon in particular has been so intertwined with the development of American law, but that bourbon has really led the way in the development of so much of the law in our country, whether it's consumer protection law, environmental law, trademark law, business competition law. The whole idea of branding comes from bourbon and so much more. I know you'll enjoy my conversation with Brian about his book about bourbon. Pour yourself a glass as you listen to this episode. Unless you're driving, don't do that, please. But enjoy this episode. Stay tuned. As we record this episode, the news around the clock, 24/7, is filled with the latest developments on the impeachment inquiry and Ukraine and other shenanigans. But we're going to have a conversation today about something on the lighter side for a change. And not only on the lighter side, but something a little bit on the sweet and tasty side. And I'm talking about whiskey. And that's what we're going to be talking today with my guest, Brian Haara, who's the author of a book that I enjoyed tremendously last night over a couple of glasses of whiskey myself, a book called Bourbon Justice, How Whiskey Law Shaped America. So first of all, Brian, thank you so much for being on Good Law, Bad Law.
Well, thanks so much for having me. I'm excited to talk with you.
Brian, you are a lawyer and a whiskey aficionado, and I'm going to ask you about that background. I just want to first say this book was so pleasurable. I have been a whiskey drinker for a number of years since a friend of mine introduced me to bourbon. And one of the pleasures of whiskey is really trying different brands and different bottles from small distilleries and really getting to know it and enjoying it in different ways. I've never enjoyed whiskey this way, though, and it was such a pleasure. And I want you to know that we're going to put a link to the book in the description for the episode, and I really encourage everybody who enjoys not only whiskey but any spirits or just a good read about some fascinating aspects of our legal history in the United States. What a great read, Bourbon Justice. So thank you for that, too. It's been great.
Thank you. Thank you. I'm glad you enjoyed it. I learned new things along the way, and it was a long research process, but you're right. I think whiskey and law go great together.
Well, and the idea that you can track so much of our law and the development of our law in this country, particularly commercial law, aspects of business law, right alongside the history of whiskey in our country, going back to the revolutionary and pre-revolutionary time in our country, is a pretty fascinating thesis. But before we get into some of the details of that, so people can have a taste, neat preferably, of the kinds of things that you cover in your book. Tell us a little bit about yourself as a lawyer and as someone who has a deep interest in this subject.
Sure, absolutely. I grew up in Michigan, where we really didn't know anything about whiskey. And for any whiskey enthusiasts who listen to this, cringe when I say I grew up not knowing what the differences were between either Canadian whiskey or bourbon or rye, but even worse than that, things like Southern Comfort I would have probably called whiskey back in the 80s and 90s. But I moved to Lexington, Kentucky, where the University of Kentucky is, for law school in 1993, and that really was my introduction, and I'll probably say indoctrination into bourbon. Even though that was at a time before the bourbon boom, bourbon was still part of the fabric of Kentucky and something you can't avoid.
Well, yeah, my wife and I were in Lexington a few months ago. We actually took a weekend to go see Paul McCartney in Lexington on a lark, and visited the Woodford Distillery in Lexington, and so I know you can't visit Lexington without tripping over a bourbon distillery. So I can see how. What was it? Was it college or law school that brought you to Lexington?
It was law school that brought me to Lexington, and then I stayed. Then I've been here ever since. I moved to Louisville 3 years later in 1996. Worked for a regional firm for a few years, and then changed firms, and didn't get into bourbon law until probably the last maybe 10 years or so. So maybe halfway through my practice, or a little bit more than halfway through my practice, before I started seeing how bourbon was everywhere in the law. And it's probably just because it's Kentucky and there's more aging barrels of bourbon than there are residents of the Commonwealth. But every distillery has all sorts of problems. They'll have trademark problems. They'll have workers' compensation claims. There's whiskey fungus that grows on the sides of warehouses and then also can spread to nearby neighborhoods. So there's environmental claims. There's anything you can think of in any discipline of the law can be handled at a distillery.
Fascinating. And we're gonna and again this idea that is really the thesis of your book, that you can trace many important developments, certainly in an enjoyable way. For anyone who thinks the law is dry and serious all the time, I mean, it's actually quite enjoyable to think about developments in the law by looking at cases that have involved some of the most prominent whiskey families and whiskey distilleries and companies throughout the last 200 plus years of our history, of our country's history, of our country's legal history. But before we get into that, so is part of your law practice bourbon law?
It is. My practice, I would say, more generally, is all commercial litigation. But that involves some representation of distilleries, some representations of employees at distilleries against the distillery, some representation of folks who want to either start a distillery or want to take advantage of Kentucky's new vintage spirits law, which allows them to buy dusty bottles on the secondary market and then resell them. And maybe my biggest bourbon case resulted in a Sixth Circuit opinion during the summer of 2018. I think not coincidentally issued on National Bourbon Day.
Oh my God! What is National Bourbon Day? I have to mark my calendar now.
Well, there's a national day for everything now, but this June 14th happens to be a National Bourbon Day, and we argued it on June 7th. So it only took the panel a week to get the opinion out. So I have to think that the lead judge on the panel had a deadline in mind and moved mountains to get an opinion out 7 days later. But that was a case involving the plaintiff was Sazerac, which owns the Buffalo Trace Distillery, and they own the Colonel E.H. Taylor and Old Taylor trademarks. And I represented a small distillery called Castle and Key, which is located at the historic site of the Old Taylor Distillery, a distillery that was built in 1887 by Colonel E.H. Taylor and his sons. It had been called the Old Taylor Distillery forever, and there was a dispute because there was still signage and the name carved into the limestone walls of the castle that said Old Taylor Distillery.
Wow. And you talk a lot about the Taylor family and some of the other big bourbon families throughout history, and I want to get into some of those stories. But for those who don't know, and I know you do because you also, in addition to your law practice, you do a lot of writing about bourbon and bourbon law. Isn't that right? You have a blog on this?
That's right. I have a blog called Sippin' Corn, SIPP' Corn. And I get, this may sound like an odd name, but I get that from an old-timer who I saw interviewed who referred to drinking bourbon as sipping his corn.
That's so great.
It's a majority corn distillate.
Well, and that's a great segue, because before we get into some of the law on this, and even what I'm going to ask you gets into some of the law on this, but for people who don't know, give us just sort of a concise lay of the land. What is whiskey? What is bourbon? What is, it would take the whole hour, I know, to get into all the minutia of the different distinctions there are. But for those who are newcomers to this topic, give us just some of the background, because it is fascinating that these definitions matter so much when it comes to bourbon.
Absolutely, they do, and they are definitions that have been in part of them in existence since the beginning of bourbon, and others that have morphed a little bit over 150 years or so. But essentially, all bourbon is whiskey, but not all whiskey is bourbon, is one way to look at it. Whiskey is a broader category of a spirit that is made from a grain distillate. So Scotch whiskey is made from malted barley. Rye whiskey is made from a majority of rye grain. But bourbon is a whiskey because it's made from grain, but it has to be at least 51% majority corn mash bill. Mash bill meaning the types of grains that are used for the whiskey. In addition to corn, bourbon usually includes a small percentage of rye grain and sometimes wheat, and it also usually contains even a smaller percentage of malted barley.
And go ahead.
Well, but I was just reiterating the basic is that it's got to be majority corn.
Okay. And to be bourbon, I think this is a popular misconception, given the prominence of Kentucky when it comes to bourbon production. But does bourbon have to come from Kentucky in order to be called or labeled as bourbon?
It does not. I found some cases, however, that originally that was the belief. Cases referred to bourbon as originating from Kentucky. Some say Bourbon County, Kentucky, even more precisely, but they really landed on it that it had to be from Kentucky and that it had to be a majority. And from the time frame of these cases, they called it Indian corn.
Okay.
And corn grew much better in Kentucky than it did out east. And when distillers moved to the frontier, Kentucky was the frontier at the time and was a county of Virginia before it gained statehood in 1792. They found that rye did not grow as well. Some of the fruit that they fermented did not grow as well, but the land was perfect coincidentally, for growing corn.
Well, and let me ask you about that, and then we'll get into some of the other more legal reasons why Kentucky became such a center for bourbon production. Let me hold off on that just for a moment. Again, because people might not understand this, and I think it is fascinating and becomes important too in how the law develops regarding bourbon, and how the law develops regarding bourbon has influenced the way the law is developed regarding all kinds of things non-bourbon too, by the way. So I think I mentioned I had a chance to visit the Woodford distillery in Lexington a few months ago, and it's fascinating. If anybody is traveling to Kentucky and wants a great daytime experience, visit any of the distilleries. The Woodford in particular has a great tour, and it ends with a tasting, and of course they then direct you to their gift shop, but who doesn't? Right. But it is fascinating because a lot of people, of course, love wine, and I think basically most people understand that wine comes from the fermenting of grapes, but the process for making bourbon is a little more complex. And you've referred to it as a distillate. So give us a thumbnail on actually what is bourbon.
Sure. So you start with at least 51% corn. It is ground up, it's mashed up, and water and yeast are added. That produces what the distillers refer to as beer. And that's really the first step in making beer. There's a low alcohol content at that time, but instead of filtering out the grain and taking the next step to make beer, that fermented mash is put into a still, and it's heated up. There are different evaporation rates for the alcohol that's contained in the fermented mash and the water. So the alcohol rises in the still and is concentrated. That creates a distillate. That is a whiskey. It's not yet a bourbon, but it's a whiskey. It doesn't become bourbon until it is stored in a new charred oak container. The regulations use the word container, but barrels are what the containers actually are. But the regulation is a little broader than that. I guess you could use a bucket if you wanted, as long as it was made from oak. It had never been used before, and it was charred. And what I mean by charred is they light the inside of the barrel on fire. There are different char levels that different distillers use, and they basically measure how deep into the wood this charcoal is created. During the aging process, the clear white distillate that comes off of the still goes in and out of the barrel wood and extracts sugars from that charred wood. And one of the reasons that I think Kentucky became the bourbon powerhouse that it is because we have all four seasons, and not only do we have all four seasons, but we have a high temperature variances, sometimes within the same season. So some people say we have 8 or 12 seasons.
Right. And that has an impact. That has an impact on the taste or the quality of the bourbon as it's aging.
It does, because every time that the bourbon barrel is warmer, is heated, the liquid expands into the wood staves through the char. And as it is cooled, it comes back into the barrel and brings with it the sugars and the color from the char. So the longer that it's in a barrel, the darker the whiskey should become, and the more flavors that it should be bringing out of the wood. If it's in the barrel too long, it will taste too oaky, and it will lose some of the sweetness of the sugars. So there's a fine art in determining when the barrel is ready.
And so Kentucky becomes a center for bourbon production, from what you've told us so far, because of its climate, because of also the water is a big part of it, right?
It's a huge part, it's a happy coincidence of several factors. It's the climate, it's the soil, it's the water. The water is important and relevant here because Kentucky is on a limestone shelf. So all of the groundwater is filtered through limestone, which removes all minerals, essentially. So you have a pure water. And any introduction of minerals into a whiskey will give it a metallic or even rusty, burnt taste. So for anyone out there who adds water or ice to their whiskey, if you live in an area that has high mineral content water, that will affect the taste of your water. Of your whiskey.
Well, and I have to say that's I never thought of it as actually affecting the taste, but as someone who does enjoy a glass of whiskey in the evening, I did used to include a big old ice cube, and I did that mainly because I was thinking, well, it's nice to have it be a little cooler. But since I visited Lexington and learned that really the best way to drink any bourbon is neat, that is with nothing in it, and now understand that there's a chemical change that takes place, not just a temperature change when you introduce ice to the drink.
That's right. It does. Ice can also, since it makes the whiskey cooler, it can numb the taste buds a little bit, and you might not be able to experience all the flavors. On the other hand, I still will add a splash of water to some higher proof whiskeys, or on a particularly hot day, I may pour it over ice, and you'll get different flavors with that, and it can change it, but not always to the bad. The key is just to make sure that you're using good, pure water, and if you're using a bottled water, definitely don't use an artisan high mineral water.
Now, you've introduced the concept of proof, Brian, and I want to understand that too, because I think it's one of those things that everybody is probably familiar with who's bought a bottle of any spirit or alcohol. It would be on the label what the proof of the liquor is. But when it comes to bourbon, all these things, as you've pointed out, are highly regulated and defined, such that if it doesn't meet certain strict criteria within certain parameters, it can't be even called bourbon. And the idea of proof is part of that set of criteria, right, when it comes to what actually is and can be called bourbon.
That's exactly right. And the other regulations that define bourbon, in addition to the 51% at least corn in the mash, are that it cannot be distilled too high. It can only be distilled to 160 proof, which is really high. But if you distill a grain distillate or any other sort of distillate beyond 160, you're stripping out all of the flavors. And part of what bourbon has lobbied for 200 years is to retain the flavors of those grains. So it can't be distilled to more than 160 proof. When it is put into the barrel, it can't be any higher than 125 proof, which is still high.
Mm-hmm. And what is proof? What does that mean? What is
sure. Proof is double of the alcohol content. So 80% alcohol in a liquid would be 160 proof.
Okay.
50% alcohol is 100 proof, and a lot of bourbons are bottled at 100 proof. The lowest that a bourbon can be bottled at is 80 proof, which is still high compared to liqueurs and those sorts of things, but 80 is probably a standard for spirits.
So actually, I don't know that anyone actually shops for bourbon other than maybe teenagers looking at the the alcohol content, but it sounds like actually somewhat lower proof or lower alcohol content bourbons will offer more flavor. You'll be able to appreciate the flavor more because it's not so dominated by its alcohol content.
I would say the answer to that's yes and no, and it depends on the proof for the alcohol percentage of the distillate when it was put into the barrel. A lot of distillers now are putting their distillate into the barrels at the maximum 125 proof. They do that because they want to save on taxes. They don't want to be taxed on having water in their barrels.
Well, that's confusing to me. How are they taxed by having water in their barrels?
Well, they are taxed by, there are gaugers who will come in and measure the amount of whiskey that is in the barrel, and you're taxed on that amount.
Oh, I see.
You can save space in your warehouse, and you can save tax by entering it at a higher proof and then watering it down when you bottle it. Decades ago and earlier than that, the traditional barrel entry proof was about 107 or less. So some of the older bourbons that you can find, if you find a true dusty bourbon, one that was distilled shortly after Prohibition was repealed, there are some of those that can still be found, were probably entered into the barrel at 107 proof, so less water going in. Depending on where a barrel is aged in a warehouse, the proof can go up or down. If a barrel is stored in a hotter location of the warehouse, think of your attic being hotter than your basement, the proof will increase while it ages. If it's stored on the ground floor, maybe in the center of the warehouse where it's not even getting heat from the exterior walls, the proof may go down. So think of a barrel that is in the middle, on the ground floor in the middle of a warehouse that was entered into the barrel at 107 proof. After 6 years of aging, that actually might be under 100 proof, and it would be perfectly fine for drinking neat without any water or ice added, and that will have more flavor. That's a situation where a lower proof bourbon would have more flavor. On the other hand, a bourbon that is entered into the barrel at 125 proof, that is aged in the high floor, that comes out 6 years later at 140 proof, that is then watered down to 80 proof, will probably have less flavor because so much of what you're buying is water.
Got it. Well, now, and the other criteria relating to bourbon that we haven't directly talked about in terms of the regulation is the aging or the age of the bourbon. So it goes through the distilling process and then an aging process in these oak barrels. But anybody who's shopped for bourbon or any kind of whiskey knows that even within brands, Woodford or Buffalo Trace or any of the big distillers will offer whiskeys at different ages, 6 year, 10 year, 12 year even. And I think there's a belief that the older the whiskey is, the longer it has been aged, that the better it is. And often we see that as being more expensive too. Is that a myth?
It's a myth most of the time, I would say. I would not recommend that anyone start out by believing that a 23-year-old whiskey is going to be the best whiskey that they've ever had. In a lot of occasions, a 23-year-old whiskey will have so many of the oak flavors and so few of the sweeter flavors from the sugar that it will seem like you're practically gnawing on a pencil or a banister. Think of those flavors, those really wooden flavors. Sometimes a whiskey can get over oaked. Now, the brands are very careful, as you might imagine, to only release the old bourbons that haven't become over oaked, but you can't avoid the oak on those those sorts of grains. If you're looking for something sweeter, you're not going to want an 18 or 20 or 23-year-old bourbon.
Interesting. Okay, so and I should know too. Go ahead.
Let me clarify one thing first on the age, because it's I think a common misconception that some statement of age is required on a bourbon, or that some amount of age is required to be a bourbon. Technically speaking, if you dump whiskey into a new charred oak container and leave it, slosh it around maybe for a second, and then dump it out, you have bourbon. Even being in the barrel momentarily will create bourbon. The law states, however, that you must disclose the age of that bourbon. So you would need to bottle it and say aged 1 second in a charred new oak container. And one, that won't be any good, and two, it'll never sell, so no one does that. But you may see some bourbons on the shelf that do say aged 1 year or 2 years. Those are some that sell. If a bourbon is aged for 2 years, then it becomes straight bourbon whiskey. And if it is aged for 4 years, it does not need to contain an age statement. So if you buy, for example, you mentioned Woodford Reserve. Woodford Reserve does not have an age statement on it. It's usually about 8 years old, but it does not have an age statement on it. You are guaranteed that it is at least 4 years old if you don't see an age.
Why would they not include the age statement, though? Because I think a lot of people probably who aren't very educated but still enjoy whiskey look at that age statement and may say, "Oh, I'm getting 10-year whiskey here. That's better. That's what Why wouldn't they want that as part of the label?"
It's a great question, and one that I've wondered about too. My only conclusion is that the brands that don't include an age statement don't want to be hemmed in by needing to age their whiskey 8 or 10 or 12 years when they are blending it among different barrels. Those brands go for a taste profile and don't want to be burdened with needing to wait until a barrel is a certain age. Because if you're looking only for a taste profile, you might combine a 15-year-old barrel with a 12-year-old barrel with some 6-year-old barrel that knocks your socks off and is unexpectedly meets that profile, but really helps that batch or small batch, which we might talk about later, have the profile that the distiller wants. And if you use barrels of different ages, you would have to use the youngest age that's included in the final bottled product.
Okay, so all right, so we talked about bourbon making and some of the reasons why Kentucky became such a center and powerhouse for bourbon. Why I found this really fascinating, that there is actually a historical and a legal reason too why Kentucky became so associated with bourbon, and goes way back in our country's history to a time when actually a lot of bourbon families were in the state where I live, Pennsylvania, and moved themselves and their bourbon making operations to Kentucky, and that has something to do with the idea of tax. So tell us about that, because that's really a huge part of the whole story and how it starts.
It's really what launched it. You're absolutely right. Whiskey production basically funded all of our wars from the Revolution onward.
Wait, what?
And that's right. There wasn't income tax at the time.
Yeah.
There weren't other taxes at the time. And so the first excise tax was on whiskey, and it was to pay for the Revolutionary War. Distillers at the time were more prominent in Pennsylvania and Maryland, and the distillers in Pennsylvania in particular didn't want to pay that tax. And the way the tax was structured, it was more harmful to the farmer distillers, the smaller operations, than it was the large, more factory industrial operations. And they, by not wanting to pay the tax, the federal government had to send agents to Pennsylvania to try to collect the tax. And there was an uprising that's lovingly called the Whiskey Rebellion. And the government suppressed the uprising, but farmer distillers fled the area. And they went to the rugged, wild frontier, which again at the time was Kentucky, and landed here finding basically perfect conditions to continue doing what they were doing, and they just substituted corn for rye.
And far away from the tax man in Washington.
That's right. They went past the reaches of the federal government.
Yeah. So, and it continues to be the case today that whiskey is heavily taxed. Is that true of all liquor, or is that true of whiskeys in particular, the amount of tax?
I don't know the answer whether it applies to all liquor or whether beer is as heavily taxed as whiskey is, but it's an incredible source of revenue for the government. It's so highly taxed. And that was part, and it has been for decades. And that's part of the reason why Prohibition failed, is because by removing all of the producers, the nation lost revenue.
Mm-hmm. So now this is a law podcast, so we should be talking about the law, but actually we have been indirectly, because all of the criteria that we went through as to what is bourbon, and we should also note that bourbon has another regulation that applies to it, which is that it is an American whiskey, especially. And so why is that? Why are these criterias a matter of law? Why is it that bourbon can't be whatever anyone wants to do with it, and however they want to call it, and however they want to make it? And what does that have to do with the law?
That all goes back to 1897 and the nation's first consumer protection law. Before we decided to protect citizens from adulterated milk, which was happening at the time, milk was being watered down, and then things like glue were being added to it to thicken it back up. Before we were protecting consumers from adulterated meat, before we protected them from anything else, the Bottled and Bond Act was passed, which protected consumers from fake whiskey. And that was led by someone who you mentioned earlier, Colonel E.H. Taylor. He was maybe one of the most famous whiskey distillers. He was a politician in his own right, and he had connections in Washington. And he helped push through the Bottled and Bond Act, which was, again, a consumer protection act, but looking at it cynically, it was a way to protect the producers of straight bourbon whiskey, because as we've talked, it takes time to make something that is enjoyable. But rectifiers, some of these distillers who were rectifiers, came on the scene. A rectifier means that they would take high proof distillate, so distilled well beyond 160 proof. It had no flavor in it at all. Some people call it neutral grain spirits. It's essentially a high proof vodka. It's flavorless, it's odorless, but it's very high proof. And they would add flavoring to it and water it down. Some of the flavoring that they added would be perfectly safe. Other rectifiers were not so upfront with what they were adding, and they would add things like sulfuric acid to give a burn. If the whiskey needed to be darker, they would dump tobacco spit in it to give it that color. They would add all sorts of things to flavor the neutral grain spirits. They could make it within a day or two, and the population bought it. And that put the producers of straight bourbon whiskey at risk, because there were no labeling laws at the time. It was all buyer beware, and they were losing the battle to these rectifiers.
So part of it is consumer protection, because who would want to drink a glass of whiskey with tobacco spit in it, but also a means to provide some protection for those who are making authentic whiskey.
That's exactly right. It was sold as consumer protection, and I don't want to diminish that. It was definitely needed for consumer protection, but it also had the added benefit of protecting an entire industry from a competitor. And
this is really, again, part of the thesis of your book, and as you've said here, this starts a movement, really, that we see even to this day. I mean, the news again is dominated by stories about the problems with vaping and e-cigarettes, and that is the latest expression of the consumer protection movement. And as you describe in the book, and as you're telling us the story today, it started with bourbon. It's incredible.
That's exactly right. Yep, I found that amazing when I learned that, and it helped me see other connections between old bourbon law and current developments in the law. Part of what I have in the book is something that I call Beyond Bourbon, where I try to give a quick snapshot of some other sort of case. A lot of them are consumer protection cases or false labeling cases that really find their roots in bourbon. There's cases about Skechers in the old commercial from years ago with Joe Namath saying how great the shoes are, and they fixed his feet and fixed his back. Well, they got sued for that. There are other consumer protection actions brought against manufacturers of sugar substitutes and yogurts and mouthwash for saying that it was better than flossing. All of those things have their roots in the consumer protection that was led by bourbon.
Incredible. Okay, well, let's talk about another way in which bourbon has influenced the law. And you alluded to this earlier, Brian, something I found so fascinating because of our cultural fascination today with the idea of brand. Not only do companies have brands and logos to signify their brands, but anyone who's ever listened to a self-help or marketing podcast or speaker on the subject will talk about a person's personal brand. And the concept of brand, again, started with bourbon. So how is that?
That was a surprise find for me. What I learned is that the federal regulations at the time required distillers to burn onto the barrel heads the name of the distillery and other required information. That was partly to always be able to track the barrel and tax it. So this really has a tax angle as well. This was a time frame in the mid 1800s when bourbon was not sold by the bottle. The glass bottles weren't mass produced yet, and bourbon was not sold in bottles, and instead the entire barrel would be sold to your local tavern or hotel. And the barrels would be behind the bar with the brand facing out that identified Old Crow or Oscar Pepper on the brand, on the barrel, and people would began asking for the bourbon that they knew they liked by that name. It was branded on the barrel and became known as the brand name, the Old Crow brand name, the Old Pepper brand name.
And I also want to note and make this additional plug for your book. You have little sidebars throughout the book that you call tasting notes. And you really do review and kind of give your take on the proof, on some of the stats regarding certain popular bourbons, about how much they cost, and your own sort of take on the flavor profile of that particular bourbon. Some of them expensive, but most of them not that expensive. $30, $40 a bottle, from Jim Beam to Woodford, which we talked about. Buffalo Trace, I'm just thumbing through here. There's Woodford again. Wild Turkey. Lots of the popular bourbon whiskeys that people know but might not know how to think about as they're enjoying it. And you offer some guidance on how people can think about what they're drinking, which is terrific.
Well, thanks for mentioning that. And I've always said that this book goes best with a glass of bourbon.
Absolutely.
And I hope that as anyone reads it and they reach a tasting note, they will maybe get some ideas, because taste really is subjective, and you'll taste something that I won't. You may have a better sense of smell and be able to pick up more aromas than I do. And so much of what you experience with a bourbon, I think, is related to your own past. I have memories of my grandmother cooking rye bread, and when I smell a high rye whiskey, that's what it takes me back to. I smell that rye and I think of my grandmother's kitchen. And bourbon can be so contemplative, and I really encourage people to sit down either at a fireplace or a fire pit or with this book or anywhere else and just really experience bourbon.
Well, I absolutely and completely agree that that's part of the pleasure of bourbon. And so, and I don't want to give the whole book away either, because we could do that if we spent another couple hours. But there are so many ways, and you talk about this, drawing on actual real cases that you pulled from court archives and other places, and tell the stories of these families, often within a family, different generational levels, ending up in court, or competitors ending up in court, as you yourself did last year, over issues relating to trademark, relating to competition or unfair competition, relating to environmental issues, as you pointed out earlier. So there's such a fascinating connection between bourbon and the law, and bourbon in our country's history. A really great book. And I want to end on a personal note here. You told us about some of the differences between bourbon and other kinds of whiskeys in terms of how they're made. I mean, rye whiskey coming from rye, and some people like Scotch, and there was a big Scotch boom for a while. Single malt whiskey, was a big popular drink for a while, and now bourbon. I mean, when I go into Pennsylvania has state liquor stores still, which is a whole other topic maybe, but I will say that Pennsylvania has gotten a lot better over the last few years. When you go to any of a state liquor store in Pennsylvania now, the selection of bourbons and other whiskeys is just remarkable. So, I think of bourbon as being on the sweeter side, tending to be on the sweeter side, Scotch being on the, kind of more acidic side, and rye maybe being somewhere in between. But like you said, it's very subjective and personal. So let me give you your shot. I mean, why bourbon? Why bourbon in particular?
Bourbon, I'm a history nut, first off. So I love the historical aspect of bourbon. I'm also call me maybe a law nerd, law geek, whatever the right phrase is. So to be able to combine the two really fascinates me. But I wouldn't drink it if I didn't like it. And what I really enjoy about the experience of bourbon, of drinking it, is all the different aromas and flavors that you can find in different brands. I think a lot of Scotch will taste similar if you're talking a single malt that is peated versus a single malt that is not peated, and that's a method of drying out the barley in the malting process. peated Scotch and non-peated Scotch are completely different animals. But I think between those two, there's a lot of similarity between different Scotch brands. With bourbon and the interaction with new charred oak, so you're getting the first chance at getting those sugars out of the wood, with the varying temperature locations within a warehouse and the conditions of aging, a Kentucky distiller can have 50 profiles come out of one warehouse. And I like to experience and find those different profiles and find what I like. And that's something that's shifted over time. I think maybe I started with more of a sweeter tooth on bourbon, and I'm enjoying more recently heavier rye content bourbons and bourbons that are aged longer that bring more of that oak with it. But there's so much variety. I think there's something for everyone.
Well, and again, to mention the book Bourbon Justice: How Whiskey Law Shaped America, Brian. You really do a great job bringing these two together, and I didn't know, and I think people will be really fascinated to know just how intertwined the history of bourbon, these Kentucky bourbon families, and the law have been shaped alongside one another over a lot of years, and even to this day. I mean, you talk about some cases from the last 5 years that have had a big impact on the bourbon industry and in other areas of law. So really great job on the book. And do you want to give us the name again of the blog so if people want to check that out?
Sure, absolutely. I appreciate that. The blog name is Sippin' Corn, SIPPN-CORN. There's also, you get to the same website by typing in brianhaara.com. You'll get there. There's more information about the book. There's links to earlier blog posts about bourbon legal issues that aren't in the book. And there's a lot more tasting notes and reviews of different bourbons and rye whiskeys.
And Haara, Brian's last name, by the way, is Haara. Check out the description for this episode, and you'll find links there to the blog, to the place where you can click and get a copy of Brian's book, Bourbon Justice, his law practice in Louisville, not right. Louisville. And share this with your friends, everybody, whether they're bourbon drinkers or might be considering that. And even if they're not, I mean, really fascinating read, and great to talk with you too, Brian. Thank you so much for being on the program. I appreciate it.
Thanks so much, Aaron. I really enjoyed it.
Great.